My
I'm,
pleasure.
I'm keyed up now for sure. Good morning, and good morning, everybody on the line. It's great to see you again today. So, Katharina is going to introduce her mind to us.
Yes, and I'm very, very honored to have Hermine today with us. So Hermine Hayes Klein is an American attorney, and she's an international advocate for human rights and in maternal health care. And when I say advocate, it's actually an understatement. To me and to many others, she's always been a lighthouse in the area of women's rights around childbirth. I know she touched many lives. She touched mine. That's what I'm doing. Why I'm doing what I'm doing is because I met her at, I don't know, when was that? In 2013. Anyway, so Hermine organized 6 international conferences on human rights and childbirth between 2012 and 2017 in Europe, in the United States, in South Africa, and also in India. And the first human rights and childbirth conference, that one took place in The Hague, and that has become history. And maybe some or even many of you have seen images of that conference because it stars in the film Freedom for Birth. So you might have images of that conference in your minds even. But for the last decade, Hermine has worked on many legal cases as an attorney and on advocacy campaigns that are related to the right to respectful and non-discriminatory maternity care, as well as access to midwifery, and the legal status of midwives in different nations, but mainly in the United States. Hermine is now based in Oregon, Portland, in the United States, and I'm so much looking forward to your presentation now on how to make human rights a reality. The floor is yours.
Thank you, Katerina, for that so kind introduction, and thank you, Joan, and to the organizers of this conference for including me in it. It's so nice to see all of you today. It's still nighttime here in the United States, which is why it's dark, but I'm delighted to be able to join you in your European morning. So maybe I'll share screen now and try to get my slides going, and then we'll dive in. Let's see. All right, I think we're on our way here. Oh, move this control. Sorry about this, everybody, to bear with me. I'm gonna move this little bar up here, out of the way, expand this, and then slideshow, play from start. There we go. All right. So in my talk today, I'm hoping to build upon what you discussed yesterday with Amy from Birthrights. I think she, from what I can tell so far, laid out a really good foundation for what are the human rights at stake in maternal health care, and what are some of the ways in which those are being undermined in practice. And so I think the reason that I'm going to focus this talk on how to make them a reality is the same reason that she brought them to the table yesterday, because we share the belief that the violation of women's human rights in maternal health care is widespread and entrenched in maternal health systems all over the world, and that the violation of the human rights of birthing people causes harm, causes trauma, causes bad outcomes, measurable bad outcomes in the forms of mortality and morbidity, as well as less measurable long-term but equally significant outcomes in the form of emotional trauma that ripples out from the patients themselves to affect their whole families and ultimately their communities. So let's dive in a little bit to what we're talking about here. If I can, let me see if I can get this little control panel out of my way. Down a little bit. All right, down here. Okay. So, oops. So, I mean, a lot of the space in which a lot of the encounters that at which the human rights of birthing patients is at stake are the moments at which decisions are being made about the treatment that any given patient will receive, and the way in which the providers and the patients work together around those decisions are the spaces in which the human rights of those patients are meaningful or not meaningful, are respected and upheld or are ignored. And so I think we can acknowledge that there are a lot of different decisions that need to be made throughout the pregnancy and postpartum period. Prenatally, there are issues like prenatal testing for a wide variety of issues, genetic testing, drug testing, issues about cord blood banking, choice of practitioner, what type of practitioner does this person feel most comfortable giving birth with place of birth. Where do they want to give birth? Do they want to give birth in the community setting? Do they want to give birth in a high-tech hospital? Planned unmedicated birth or medication, pharmacological pain relief, induction and augmentation. And then there are, so, something to flag with regard to decisions that are made in maternal health care is that different kinds of decisions are made in different kinds of time frames, right? Some of them are made at leisure in the clinical office prenatally, where there's at least theoretically more time to discuss the alternatives available, et cetera. And some of them are made um, in more pressured situations, during labor, during even the second stage of delivery, like, for example, the choice of whether to use instruments to help facilitate a delivery, like the forceps or the vacuum, the choice of whether to cut an episiotomy to facilitate a delivery, the choice of cesarean section, either when, elective or planned, or what they call emergent, although sometimes what is called an emergency cesarean is simply a cesarean that was decided upon in labor as opposed to before labor, even if the reason for it is simply mom's tired and doesn't want to do this anymore, or is overwhelmed. And then postpartum care, there are decisions to be made throughout that. And the thing about decisions in maternal health care is that there are often a lot of options at each choice point. It's not, I think in other areas of medicine, the range of decisions or the options that are available for a given condition might be simpler and more straightforward. If I break my leg, there are some pretty straightforward ways for that problem to be resolved that can be offered to me by my provider. And I'll accept them setting my leg or putting it in a cast or whatever, giving me a boot, or I won't. It's not the case for pregnancy and childbirth. A lot of the decisions that are being made, there are a range of choices available. Think about any of these, from prenatal testing and genetic testing, and why and how a pregnant person might want that information or choose not to gather that information, through all of the different kinds of decisions that are made about pain relief, about induction of labor and the timing of labor, around choice of practitioner and place of birth, around cesarean section. And there are usually multiple options at each of these moments, and each of those options carries its own set of risks and benefits. And so it's really actually not very helpful to talk about risk in childbirth, even in terms of high risk and low risk, because the reality of the way that risk plays out on the body of an individual patient, or even in these decisions, is that risk is a spectrum, and that to analyze risk either in a pregnancy itself, is a high risk pregnancy or a low risk pregnancy, really you're looking at a constellation of risk factors in that pregnancy. And similarly, with regard to any of these decisions, if we're actually having a meaningful analysis of the options available, we're going to recognize that there are risks on all sides. And sometimes the risks are higher on all sides, but there are still risks on all sides. For example, when a patient has had multiple cesarean sections, right? The choice between repeat cesarean section and a vaginal birth after cesarean, there's no high risk, low risk choice here. There are higher risks on all sides. If she has a vaginal birth, she's at an elevated risk of a uterine rupture because she has a uterus with multiple scars. And if she goes for yet another cesarean, she's creating a whole nother set of significant risks, especially if she hopes to continue having children and have a large family. So decisions are complicated, and they are numerous throughout the pregnancy period. And then when we have these encounters around any of these decisions, one more point I want to flag with regard to these, with some of these decisions that are being made are actually largely in the hands of the providers, like drug testing. Often the client isn't actually included in the decision of whether to drug test a birthing person who has shown up at the hospital, and it's left to the discretion of the provider. And when choices are discretionary, there is more room for, say, unconscious bias. And so a lot of what we're going to be looking at are what are some of the biases and preferences that are brought to these decisions by all involved, and what are the spaces in which unconscious bias and discrimination can be brought by the providers unwittingly into the encounter with discriminatory impact. So I made this little Venn diagram to try to capture the fact that both the providers and the patients are bringing multiple variables to their analysis of what is the best decision for this patient with regard to whatever decisions being made. Often the way that these decisions are discussed when we talk about informed consent in obstetric decision making, folks talk as if the provider is really just looking at the chart, the clinical situation, while the patient might be bringing in all of this soft stuff like their cultural preferences and values or their trauma, for example. The reality is that both the provider and the patient are bringing in a multiplicity of factors. Both of them are looking at the clinical situation. Both of them, if I had the skill to fill in the center of this Venn diagram, I would put healthy mom, healthy baby in there, because they share that goal. Everybody involved in an obstetric encounter shares the goal of a live outcome, and really a healthy outcome for the mother and the baby. And then beyond that, and so that means they're both concerned with the clinical factors, but how they understand those clinical factors and how they come down on what between the different options is the best option is affected by a lot of other factors that are brought often unconsciously into that analysis. So for the provider, their institutional culture, what their colleagues want them to do. For example, they're with a patient who has a breech baby and they're talking about that patient's options. It's going to affect how they feel and what they bring to that discussion if they know nobody at their hospital is going to support them if they support this patient in the choice for a vaginal delivery. Similarly, resources. What are the resources of the institution and how does that affect what I am able to offer a given patient? For example, can I offer them an elective cesarean section given the other pressures on our surgeries, given the resources available to us? How is what can be offered legitimately and illegitimately affected by the constraints of the institution? Skills and training. This is often not discussed explicitly. Of course, many of these additional non-clinical factors are not put on the table explicitly in a way that can be acknowledged honestly within that discussion. So again, in that breech discussion, it's the way that conversation usually looks is, well, your baby's breech, and so we recommend a cesarean section. And the way that conversation occurs leads the patient to believe that the reason for this recommendation is that a vaginal breech delivery is simply too dangerous, that it's dangerous when breech babies come out of vaginas. What is not said is, listen, I want to offer you a cesarean section because I actually don't have the skills to do a breech vaginal delivery. I've never even seen one, to be honest with you, let alone, especially a physiological one like you're asking for, where you have the freedom to move around. And if I were to try to support you in that, I might hurt you and hurt your baby. And honestly, I don't know a single person at this hospital who does that. But maybe somebody at the hospital down the road, right? That would be a more honest discussion about options for breech, but that is very rarely said. And so the patient is left with the impression that the body itself holds the danger rather than the ability of the provider to offer assistance with what's going on with the body. Medico-legal concerns do affect the way that providers think about what they can offer in the situation, and are they safe to support this choice over that choice. The United States are famous for having a liability crisis that governs or strongly affects medical behavior, but we're not the only nation with this problem. The threat of law, whether that's in the form of a tort lawsuit that, with a risk of liability, or a complaint against your license, risk with your licensing boards, there are multiple avenues of sort of legal risk that providers can face that can make them feel nervous or restricted about having genuine informed consent conversations. Economic incentives. The law and economics literature is robust and it is extensive to show the correlation and causal link between economic and time convenience incentives of providers and the C-section pandemic. The studies have shown that what actually has driven the C-section pandemic for the last 30 years is not, in fact, fear of liability, even though that's kind of the obstetric story, that fear of liability made us do it. In fact, what those studies have shown is that fear of liability has a less significant effect on that pandemic as a driver than economic incentives. For example, measured in the fact that for-profit hospitals have skyrocketed C-section rates compared to not-for-profit hospitals, and then the time convenience incentives of the providers. And needless to say, providers are not consciously thinking, probably in the vast majority of the time, I'm going to do this because it is more convenient for me. These kinds of incentives affect us unconsciously because we are human. and similarly, experience and trauma. It affects both the patient and it affects the provider. And in the world of the healthcare providers, because there's so little acknowledgement of provider trauma, there's not a lot of space for them to process that and therefore keep it from spilling into their next patient encounter, right? So I've talked to the providers who say, listen, you haven't seen when a woman falls on the floor, with a heart attack, and we have to do a C-section right there on the floor. Or I've stood next to the surgery with so much blood I'm standing in boots, and it's like, and all of this is being carried with them, and that might have nothing to do, say, with a transferring home birth, but because that situation around their trauma felt so chaotic and out of control, and now here comes a home birth that feels chaotic and out of control for different reasons, but I'm going to transfer my trauma around chaos onto the home birth and be really angry about it because I have unprocessed trauma. So in that sense it does spill in. And so similar on the patient side, we know that the patient is concerned with a healthy the clinical factors in a healthy outcome, but the reason that the law of all nations rests the right of medical decision making with the patient is because the law acknowledges that medical decisions are made not only on the basis of clinical factors, but on the basis of numerous other factors that then shape the patient's relationship to those clinical factors, and that this is legitimate. It's legitimate for a patient's culture and values and preferences to drive and affect their preferences for the pain relief, for induction, for how they want to do this birth, for choice of provider, for location of the birth. Family planning, are they planning on having many babies, or is this their last baby? That would legitimately affect their analysis of your recommendation for cesarean section, but again, that there's not a lot of space in a lot of informed consent conversations to recognize that the variability that should be anticipated by the variability of patients with regard to these kinds of issues. Postpartum support, who's going to be there for them after this birth? Did they have a traumatic former cesarean where they couldn't get out of bed for weeks, and so they're like, listen, I need to have a vaginal birth this time because I can't go through that a second time because I don't have the support to be able to care for my baby if I'm home recovering from surgery. Economic incentives are legit for patients. Here in the United States, people have to pay for their health care a lot of the times, even after the Affordable Care Act. And that absolutely affects their willingness, for example, to utilize certain prenatal tests to get that last ultrasound, and they're the ones living with that bill. So unless the provider has a solution that enables them to access that healthcare for free, they really do have to weigh whether they can afford it. And similarly, experience and trauma are valid and real factors that affect the patient's analysis of what is the best decision for them. And what we have to understand with regard to this is that, science tells us what science tells us, but the way that we talk about what science tells us is shaped by our values, right? So so the science can give us the numbers on risk, but then where we come down in terms of what should this mean, what should be offered, affects, which risks matter, right, is a function of our values. So what we know is that in these informed consent conversations that are happening during a labor intrapartum informed consent conversations around issues like, should we just go for that C-section at this point? That from the provider perspective, their medical risk is prioritizing short-term perinatal risk. They want a live baby at the end of this labor. And what is being undervalued by the providers in those conversations are future risks. In economics, there's the concept of the externality, right? An externality is any cost of a transaction that is not internalized in the transaction, but is instead externalized, sent downstream, so somebody else has to pay that bill, right? What is C-sections and the recommendation for cesarean sections very often externalize a lot of the risks associated with that intervention, and there are other intrapartum interventions for which this is also true. Future risks are undervalued, or if they're even discussed. Risks to the mother, risks to this baby from the mode of delivery for this baby, and risks to future pregnancy. And really all risks to the mothers are undervalued, including short-term ones. Like if she's alive, she should send them a thank you note, is kind of the attitude. So, I want to circle back to what are the human rights at stake in these encounters? And I know that Amy touched on this, but it's worth circling back again. Informed consent and refusal is a legal right that is written into the law of each state here in the United States, state by state, and into the law of different nations. But that legal right that is encoded by statute or regulation rests on a universal human right. And that universal human right is the human right to physical autonomy. I own my body, so I get to make the decisions about what happens to this body at all times, including when I go in for medical treatment. So when I go into medical treatment, I'm not going in to hand over my body and have them, let me know when they're giving it back when I check out, but to engage in a process of receiving services in which I will be respected as the central agent of my care. And so that translates into the right of informed consent and refusal and the right to refuse surgery, which should be named as such. This is a human right, and it's recognized as a constitutional right here in the United States, everywhere except in the culture of obstetrics, in which the right to refuse surgery is ignored not only by individual providers, but perhaps more importantly, on an institutional level by hospitals that say, at this hospital, if you, with your condition, whether it's twins or a prior cesarean or a breech, or maybe just a pregnancy, walk in here, you're getting a surgery, and you don't have a meaningful right to refuse that unless you want to go give birth by yourself. We will abandon you if you want to exercise that right. So that's the right to physical autonomy. The right to privacy is a little bit different. That's the right to make private decisions about your life, to make personal decisions, the decisions that are most personal and sacred to you, and to have those decisions be respected, right? And so that's all your rights to reproductive choice, because your rights to reproductive choice are not only your rights to medical choice and rights related to your physical autonomy, but also to your life plans around those aspects of your life that we recognize to be sacred, which are reproduction, family, and our most personal, private aspects of life. The human right to equal treatment means that everybody gets to access healthcare in which they are treated, they receive non-discriminatory and culturally competent healthcare. If you're not receiving culturally competent healthcare, then you're not receiving equal treatment within healthcare, because some people are getting culturally competent healthcare, but you're not, and that's not equal. And when it's not culturally competent, it's far more likely to be discriminatory. And then, as has been recognized by the World Health Organization with its Millennium Development Goals, we have a human right to skilled obstetric care and the right to access skilled providers and emergency care. I think it's worth thinking about, what does that mean today? The human right to access skilled obstetric care. What kind of skills do we actually have a right to be able to access? I want to touch for a moment on this concept of informed consent and refusal. Again, it's not just a moment, this is my whole talk. This law is based on bioethics. Laws have different kinds of foundations. Some laws are based largely on utility. This is our law around contracts, for example, because this is the law that makes contracts work in the world and makes people able to enter business agreements. With this particular law, we're not just basing this law on utility or what makes things work, but on bioethics, on, how do we want medicine to work in the world? This is as old as modern medicine. So really, since at least the 19th century, the law of informed consent and refusal has been recognized as fundamental to bioethics, and then the law rests on the platform of bioethics. So what's interesting to note and important to advocate in places where this has not yet been addressed is that places that have addressed this issue have pointed out that because informed consent and refusal rests on bioethics, it is fundamental to the standard of care. Its violation is negligence per se. Whatever it is that you're doing, you should be doing it with informed consent and refusal. And because it's fundamental to the standard of care and rests on bioethics, it differs from other areas of medical negligence, in that in other areas of medical negligence, the providers get to say, well, this is how everybody else does it, right? So this is how everybody else sets a broken leg, and I did it just like them. Or this is how everybody else cuts a cesarean section. And if they do it that way, even if it's not necessarily the best way that it could be done, you are not negligent because you have met the standard of care within your profession. With informed consent, you don't get to say that. Even if every other provider is violating informed consent chronically, you have a unique, just on you, rests on you, individual obligation to respect the law of informed consent and refusal, and you don't get to get out of it by saying nobody else does this. Granted, people try. And I think it's worth touching on this concept of shared decision-making, which has become the way in which modern healthcare seems to talk about informed consent and refusal. When they're even willing to tiptoe in the direction of talking about it, the word that is given, the phrase that's given to it now is shared decision-making. that's okay if it gets us talking about decision making and the fact that is more than just the provider involved in that decision. It's shared decision making is a valuable concept in that it points to the fact that informed consent and refusal requires a conversation, and the conversation is shared and information is shared. But the problem with the phrase shared decision making is that it obfuscates the fact that this decision itself is not shared. By law, the decision itself belongs to the patient. And so I think we should note that modern obstetrics has embraced this phrase shared decision making without clarifying the law of informed consent and refusal. And so what it allows it to do is continue to sort of blur the lines around whether the patient actually gets to make the decision all by themselves. But the law says that they do, no matter how often the OBs try to use the phrase shared decision making. The conversation is shared, the decision is not. So what should informed consent and refusal look like, but so rarely does in obstetrics? And why am I spending so much time on this? As you're going to see, I mean, what I'm here to argue is that if maternal health care wants to prevent perinatal trauma, the way to do that is to respect informed consent and refusal. There is no effort to reduce, minimize, or eradicate maternal perinatal trauma that doesn't start with respecting the agency of the patient. That doesn't start with recognizing that the problem, the reason I do this work and that so many of you do this work, is that there is a significant gap between the law of informed consent and the culture of obstetrics. The culture of obstetrics does not respect the law of informed consent, not as it applies to birthing people. Now, I'm not an expert in all areas of law, so I don't know, it might be weak in other areas as well, but I know that it is especially weak in the area of obstetrics. As you will see when you consider what it's supposed to look like and the gap between what it's supposed to look like and what it actually looks like in L&D, labor and delivery, all over the world, outside of New Zealand. Just kidding. So, what the law always says about informed consent and refusal is that the provider is supposed to inform the patient of their treatment options, the risks and benefits of the alternatives available to them, and to support them in making the choice about what they want to do. So let's break that down a little bit. What I like to note is that to do that appropriately, you would actually break it into 3 prongs, right? And the reason for this is that informed consent implies 2 prongs: the inform piece, which is very important, and the consent piece, which is also very important. But the way in which the inform piece often plays out in the provider-patient encounter is that the way that the provider gives the information about the alternatives and the risks and benefits of those alternatives is shaped and colored by the provider's advice for what they think the patient should do and what they think is the best option. And that doesn't meet the provider's obligation to the patient to make sure that they have that objective information and are able to make that decision on the basis of the objective information, but maybe also be able to receive the advice of the practitioner. So that's why I recommend breaking it into these prongs conceptually. The first prong is going to be inform, and even inform has 2 parts. One, talk about, well, here's what I see your condition to be. I mean, very often the pregnant people that I work with, they're never told, even they won't know years after the birth why their baby was in the NICU for 8 weeks, literally. They don't know why they had that C-section. They don't know, they were told, well, with blood pressure like yours, our recommendation is to induce at 37 weeks. Nobody says mild gestational hypertension or expresses a diagnosis that the patient could then Google, do some research on, and understand what is the diagnosis for which you're offering a treatment. So really, what's the condition? What do you see to be going on with the patient's condition? And then given what you perceive to be going on, what do you see to be the full range of options, treatment options available? And that should always include the option of doing nothing. If we do nothing, we expect blah, 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 the risks. And so then part 2 is, now that I've told you your condition and the options, let's talk about some of the risks and benefits of each of those options. And this should be, first of all, it doesn't have to be exhaustive, right? You're not going to be able to list every risk that could possibly come with any given treatment option. And so that's why it generally comes down to the material risks. And material risks are often defined as those that would be relevant to a reasonable patient, those that might make this patient make a different decision if they had that information, that this was a risk. And it has to be accurate. there's a lot of lying going on in obstetrics. I think we know all around the world in the places when that you have your 80 to 100% C-section rate, a lot of women are told it's simply safer. It would be dangerous for your baby to be born vaginally, and even that sort of implying that she'd be a little selfish to want a vaginal birth because the safest thing for her baby is a C-section. That is just not accurate. That's not what the research shows. And so that's misinformation right there. So it should be accurate. It doesn't have to be exhaustive, but it should be material. So that's objective information. So then once you've given the objective information, you can come with your subjective advice, right? You can say, that's the objective information, but here's what I think you should do. And you providers know better the situations where it's actually imperative, you think, for you to give advice, and where you don't even, sometimes it might not even be necessary. You can say, here are your options. What would you prefer? Like say with pain relief or whatever. But there'll be other times where you feel like, no, I need to let them know that I really think this would be the safest option for them and their baby, and give that advice. But once you have done that, and that can be subjective, that's just your perspective. Once you've done that, or as you do that, you need to make clear that the client still gets to make the decision, and that they still have your support for making that decision, including the decision to go against your advice. Once you give the advice to your patient, there's a dynamic that is created in which there's a concern that if they go against that advice, they might be offending you. And there's what birthing people want to tend and befriend. If we as females are socialized to tend and befriend, we're never going to want to do so more than when we're in labor, in our literally most vulnerable state, right? So if you're actually wanting to support this person and being able to make a free, informed decision, you're going to let them know, so here's my advice, but I'm not making this decision. I truly support you in weighing everything that I've just told you and making your best decision. Keep my eye on the time. I better hustle. So why should we think about
Hermine? It's okay.
Thank you. I'll move this along. We're doing fine. A lot of what happens in obstetrics currently is that the providers simply take the decisions. And a lot of when the providers then talk about how can we do consent better, we should do a better job of telling them what we're going to do to them. There's a lot, and a lot of the violence that happens in childbirth, including, and I will categorize as violence, a provider getting a court order to impose an intervention on someone, happens because the providers truly believe it and state in those moments that they're right, she's wrong, and something real bad's going to happen unless she follows their advice, whether there's a fetal heart strip or 2 cesareans is just too dangerous for a vaginal birth or whatever. The provider truly believes, I'm right, she's wrong, that's too dangerous. But some of the things that can perhaps cause the providers to check themselves a little bit are, for example, as American College of OB-GYNs has pointed out in its ethical statement saying, don't force treatments on women, we can acknowledge prognostic uncertainty. We don't actually have a crystal ball, even including with the, Lord knows, the fetal heart monitor I think there's a wonderful Texan lawyer named Thomas Sartwell, Sartwelle. He's written a number of articles in his retirement after like a 50-year career in working on cases involving the electronic fetal monitoring, of like analyzing the way in which it's misused, medically and legally. And he points out that it has essentially a 99% false positive rate when it comes to predicting fetal death or cerebral palsy. And so that's just one example of prognostic uncertainty. You might be really nervous about that strip, but we know that strips are fallible, right? So let's have a little humility around it. In some situations, and others, your strip is telling you with more certainty that someone's really, that the baby's really struggling. Variability, just the variability of intervention rates should be cause for provider humility. In the United States, the C-section rate varies from 7 to 70% across hospitals, and the studies show that has nothing to do with the patients that present at those hospitals. It's not because some hospitals care for sicker patients than others. It's because, in fact, that variability comes down to provider preference. And provider preference is not just, it's more likely to be the institutional provider preference, the preference of the institution than the individual providers, but it is both. And, again, as another reason to hesitate on operating from the place that the provider knows the patient does not know, so the patient should be pressured or convinced or even forced, is that we know that that kind of dynamic of wanting to even impose force occurs discriminatorily. We know that here in the United States, for example, the rates on which the providers will call in child protective services on patients of color versus white patients for resisting medical decisions that their providers recommend is dramatic. Anybody can be threatened with CPS if they disobey, but Black women, Latina women, Indigenous women, they will call CPS on them because they know so well how to do so because they've been doing it for years. And then the traumatic impact is that much. It is so powerful that it's a form of reproductive terrorism on people of color in the United States. But these discriminatory impacts against marginalized, vulnerable communities occur in every nation. And of course, when providers treat patients with disrespect and abuse, patients don't trust coming to those providers. We have the studies that show that in the developing world. It is also true in the developed world. The rates of unassisted childbirth have skyrocketed in the last decade. All of these women are not insane. There's so many women who can't access midwives, for example, or midwives who are legally able to support them in their choices, and who do not trust the medical institutions that they have encountered before, that they will respect their rights to autonomy, that they feel that the safest option for them is to stay home and give birth alone. And so again, if you decide that you're not going to try to blow them all off as insane, then you have to ask yourself, what does it mean that these people feel that this is their safest option? And so then again, I think we can look at that question back to the sort of skilled labor support of what are even the options offered to women now. Very often women describe these encounters with their providers as, you can choose any color you want as long as it's Black. So the woman says, they say, we would like to induce you at 37 weeks, and she says, well, what are the risks and benefits? And they say, well, babies just do better out than in. And she says, well, is there anything else available? Well, our very strong recommendation is just that you do this, and that no other option is discussed in a way that leads the patient to believe that they would actually be supported in that. And that phenomenon is occurring with regard to vaginal birth in the face of numerous clinical conditions, that vaginal birth after cesarean, breech in twins, the choice for physiological birth is often, is that even available to women? And when did it become acceptable for a maternal health system to not be able to support a person in simply giving birth to their baby who doesn't need to be injected with anything, who doesn't need to be cut? Why is it so hard for women in so many nations to find healthcare support for that? Because it's so hard for them to find access to midwives who are actually able to do their job, the job of midwifery care, in fully supporting a physiological labor and not intervening unless it's actually necessary and consented to. While in many parts of the developed world, support for vaginal birth is cut off in the face of complexities like prior cesarean or twins, in other parts of the world, the choice for vaginal birth is cut off for everybody just because they're pregnant and because cesarean section is really what this hospital is offering. Hence the Brazilian joke that the only reason you wouldn't have a cesarean section is because your doctor is stuck in traffic. Which raises the question, when did medical support for vaginal birth become a treatment option that can be withheld? We're sorry, that's not just on the menu. The only thing on the menu for you is surgery, and forget your right to refuse surgery. But yet that's what happens. What happens when they say, you can choose, all that we can really offer you is a cesarean section? Well, we can't say that that has ever been consented to. We can't say that consent has occurred in any situation where a woman was told that she had consented to a cesarean section if she was not offered meaningful support for vaginal birth. And then when those patients actually try to say, that's not what I came here for, then those situations can unfold in a lot of different ways that are described by those patients and experienced by them as coercion, as bullying, and sometimes through the use of force. Another thing that happens when institutions allow themselves to withhold the option for we're just not going to offer that for breech babies anymore, is that when that surprise breech happens, which it does, or when that strong patient comes in who is not and has the partner that's going to support that patient and not consenting to the cesarean section, those providers are in a real pickle because they don't know what they're doing. And that to me implicates the Millennium Development Goal of the human right to skilled obstetric care. Again, when did maternal health care decide that the skill for understanding how to manage a breech delivery was something that they didn't have to bother with anymore? I find that incredible. Some of the issues that are what's happening from the provider side that make these dynamics happen. No providers coming into maternal health care wanting to cause harm, right? Or if they are, their numbers are so small that it's not significant. The vast majority of providers are there to do good, want to help, so what is happening that creates these moments where somebody's using force or bullying a laboring woman? Well, really, at the heart of this slide, the real issue is fear on the provider's part that they are responsible for the outcome of this birth, and belief that if they support this client in her choices, there's going to be a bad outcome and that they will be held responsible, even though she made the choices that they believe caused the bad outcome. And that's why legal advocacy is important to clarify that line where the provider's responsibility ends and the patient's rights begin. Because the idea that the provider is responsible for the outcome is based on a fiction, even a hubristic fiction, that flies in the face of everything that we know about childbirth. There is no setting that can reduce, perinatal death to zero. That just doesn't happen. Some babies will not survive. Some mothers will not survive childbirth, despite the best efforts and intentions of everybody involved in their health system. And that fact means that those deaths will occur without it having been anybody's fault. The responsibility of a provider of maternal health care is not to ensure that every birth ends with a live baby and a live mother. Their responsibility is to provide the services for which they are skilled, trained, and licensed in a way that is non-negligent, in a way that accords to the standard of care, and in a way that upholds the human rights of the patients that they're serving. That's their responsibility. If they've done those things, according to their standard of care, done their work in a non-negligent way, and respected their patients' rights, even if a bad outcome occurs, they cannot be held responsible for it. But advocacy is necessary to make that clear. I remember years ago, I talked to a Dr. Andrew Kotaska. Some of you might have heard his name in Canada. He's an advocate for vaginal breech, and the fact that providers should know how to do it. And I said to him, it wasn't that long, it was 2014. I said, Dr. Kotaska, in the US, doctors say, I couldn't possibly support a woman in a breech birth because if I did and there was a bad outcome, I would get sued and blamed. What do you think of that? And he said, that would never happen in Canada. I know that if I were to support a patient in an informed decision and the patient were to come back later and say, he shouldn't have allowed me to make that choice because I didn't understand the risks, my professional association would provide me with an attorney that would make absolutely clear for that court that I cannot be held responsible for a client's informed decision. And he was right. So to the extent that any court has ever ruled otherwise, it was because there was a failure of advocacy that resulted in a bad ruling that needs to be overturned with better advocacy in the future. Because what the law has to mean is that the provider is not responsible for the patient's informed choice. The provider's responsibility ends where those patient rights begin. I want to spend a couple minutes on a case, a European Court of Human Rights case that touched on all of this. This was the case of Konovalova versus Russia that went before the ECHR in 2014. All we can really glean from the fact patterns are that which are written into the opinion. For those of you that don't have legal experience, many law cases, people bring their legal disputes to a court. The court looks at all the facts, and then very often courts will explain their decision in what they call a written opinion, in which they explain what happened, what are the relevant laws in this case, and how do we, the judges, see these laws to apply to this case. So what's our decision and why do we make this decision? And so all we really know about what happened in this case is what's in the court's opinion, the European Court of Human Rights opinion. But they explained that this woman, Miss Konovalova, arrived at this large teaching hospital, and that she was provided either, I think, right when she arrived for the labor, with this little windy in here, y'all. I'm gonna have to close this window. But she arrived for this labor and was given a little booklet that said, we ask you to respect the fact that that our, treatment in our hospital is involved with teaching, and all patients are involved in the study process. Later, the hospital argued that she therefore didn't have the right to decline the presence of students during the birth of the baby. So she arrived, and what she basically seemed to allege, again, I'm only getting an abbreviated court version of it, was that she arrived at 9 a.m. and that a doctor sort of managed her delivery over that day to make it so that he could deliver her at 9 a.m. the next day in front of students, put her to sleep and then turned it up, would turn the labor off, turn it on, turn it off, turn it on, and then all these students crowded in for the delivery the next morning. She said that she said, please get them out of here, and they ignored her. A hospital expert testified, I found this interesting, and it was accepted by the Russian courts. Childbirth is stressful for every woman. During the bearing down phase, a pregnant woman is usually focused on her physical activity. The presence of the public could not adversely affect her labor. So despite the fact that Ms. Konovalova was clearly traumatized enough to bring this lawsuit, the hospital expert is claiming the authority to essentially nullify her perspective and experience and say, let me tell you how it is for birthing people. It doesn't matter how many people are in the room. They're so focused on their physical activity, it couldn't possibly adversely affect her labor. And so the Russian court dismissed her argument that she had objected to the presence of the public as unsubstantiated because the doctor said otherwise. They accepted the oral submission of her doctor that no such objection had been made, and they did not verify the doctor's statements in this respect by questioning anybody else. I think it's very interesting that Ms. Konovalova basically charged that the treatment that she had received during this birth violated 2 articles of the European Convention on Human Rights. One, Article 8, which is the right to privacy, the right to respect for private and family life, his home and correspondence, because they haven't caught up yet. The fact that there's 2 sexes in this world. 3. And then also Article 3, the right to freedom from torture. She actually brought this lawsuit saying that her right to freedom from torture and her right to freedom from inhumane and degrading treatment and punishment had been violated by the way that she was treated by these providers during the birth of her child. So the European Court of Human Rights ruled for her on the right of informed consent as covered by the right to privacy. And the discussion is important because they point to all of these instruments, which should make very clear for every doctor and hospital that any of you work with, because you're going to go in there and they're going to say, yes, we know about the right to informed consent, but what if the baby's in danger? That's what they're going to say if they haven't said it to you already. And, and what really this comes down to, if the question is, does the right of autonomy and the right of informed consent also apply in childbirth? And this addresses why, in fact, it does. First, it makes clear that the right of physical integrity, the right of privacy encompasses the physical integrity of a person, since your body is the most intimate aspect of your private life. And medical intervention, even if of minor importance, constitutes an interference with this right. I mean, again, back to the idea that values shape our analysis. Very often, what seems like a procedure of minor, a C-section can seem like a procedure of minor importance to one person and not seem like a procedure of minor importance to another. But this makes clear that even if you do see it that way, the right of autonomy and the right of privacy mean that you have a right to be free from that unless you consent to it. And then they point to various instruments that make this clear. The Convention for the Elimination of Discrimination Against Women makes clear in its Articles 20, 22, and 31 that women have a right to be fully informed of their options in agreeing to treatment, including likely benefits and potential adverse effects. So this is the law of informed consent written into the Convention for the Elimination of Discrimination Against Women. And it makes clear states should make sure that women have access to quality healthcare services that are acceptable to them. And what acceptable services are those that give full informed consent and respect dignity, guarantee confidentiality, and is sensitive to needs and perspectives. I just want to reiterate, informed consent is not a signature on a form. So giving fully informed consent is not telling her what you're going to do to her and then having her sign. It's State parties should also require all health services to be consistent with the human rights of women. So again, like, the Millennium Development Goals encourage state parties to ensure this human right to survival for birthing people, and to ensure that everybody had access to skilled obstetric care and emergency care, and that state parties could not act like, well, childbirth is deadly anyway, so they died because childbirth is so dangerous. But what it didn't do is ensure that all of those services had to be delivered in a way that also upheld all of the other human rights of the people that were trying to access those services, with the result that that under the Millennium Development Goals, the developing world developed these C-section assembly lines in order to achieve or move toward the right of survival. But those systems of care that were developed chronically violate the rights to autonomy, privacy, confidentiality, and informed consent and choice, in addition to freedom from discrimination and the right to equal treatment. They point also to the Convention for the Protection of Human Rights and Dignity of the Human Being with regard to the application of biology and medicine, and just again make clear that the right to free and informed consent is necessary, and that informed consent may be withdrawn at any time. This is also critical for maternal health care. They don't get to say at the hospital, well, she signed the form on the way in the door, and so it doesn't matter that she said no later to the episiotomy. Even if you signed a general agreement for care, you have the right to say no at any time to being touched for any reason. So the European Court of Human Rights ruled for Ms. Konovalova on Article 8, saying that the Russian courts had erred because they just listened to the doctor, they didn't listen to her, and they didn't look at the fact that, the notice that they gave really didn't give her a chance to say no. She wasn't really given the right to say no to those students, so that they said that she really wasn't then given the opportunity to actually consent to it. But interestingly, the court rejected her claim to freedom from torture and inhuman and degrading treatment by doing the same thing that it said the Russian court was wrong to do on the right to autonomy. They said, well, she said that she was tortured and subjected to inhuman treatment during this birth, but a panel of medical experts rejected that allegation as unfounded, and we can't find anything in the file to conclude otherwise. So I found this fascinating because, again, her voice is not heard in this proceeding, but the very fact that she evoked Article 3 tells us something very significant about the way in which she experienced this birth. And that's related to the concept of obstetric violence. So obstetric violence is the concept that has been developed by women who experience their births the same way that Ms. Konovalova did. This began out of Latin America, South America, Central America, the nations of Mexico, Chile, Argentina, Bolivia, and Venezuela have all passed laws that explicitly name and forbid obstetric violence, because that is the phrase that they found to accurately describe their experience of care. And it's certainly worth noting that the nations in which women felt called to actually name this phenomenon and pass laws against it are some of the nations with the highest rates of cesarean section, in which women are experiencing coercion and abuse at some of the highest rates. And so the way in which the law and the concept of obstetric violence has since been developed and understood by the United Nations and the World Health Organization is to understand that it can happen both through individual encounters, but also systems themselves can create and perpetrate obstetric violence. So individually, it's through encounters like forced cesarean section, episiotomy, forced use of forceps and vacuum. And what do we mean by forced? Often it's simply the traumatized women who come to me with vacuum stories. They came into the room because the strip was looking funny. No, they stood around. The provider stood around, looking really nervous, but didn't explain why. And when the couple says, "What's going on? What's wrong?" they're not given any information. And then only at the last minute, after sitting around for 10 or 20 minutes, does the provider then stick a vacuum into her vagina. She had no idea this was coming. She had no idea anything like this was going to happen. And the effect is traumatic. So again, that's not force in the sense that she's saying, no, don't do that to me. But it is force in the sense that there was no warning and there was no consent. Any unconsented medical procedures or touching can be experienced as violence, and physical restraint, which happens in childbirth, and other abusive conduct. But similarly, policies withholding support for vaginal birth, coercion through judicial intervention or child welfare. We discussed that a little bit at the beginning of this hour. Any place that is occurring, you're looking at institutionalized obstetric violence, and you're looking at a phenomenon in which the medical authority has the power to leverage legal authority to impose violence and force on birthing people, with a predictable effect that your rights of unassisted birth are going to go up in that area. Coercion through withholding treatment, manipulating information, or applying emotional pressure is all experienced as traumatic by patients and can leave them with lasting trauma. I mean, all of us who work in consumer advocacy in this area speak with women who are years out from their birth all the time, years out, and very often living with serious physical injuries from these unnecessary C-sections to which that they were, or unnecessary other treatments, but their physical injuries to them pale in comparison to their trauma and what they want some accountability for, and what they wanted to, the reason that they want to take action to ensure that this does not happen to anybody else is because of the trauma that they are experiencing as a result of the violation of their right to consent. This wonderful report of the UN Special Rapporteur on Violence Against Women, Its Causes and Consequences, with a focus on childbirth and obstetric violence from 2019, identified some root causes which are worth looking into further: health systems, conditions, and constraints, discriminatory laws, and harmful gender stereotypes, but of course, not only gender stereotypes, racial stereotypes. In this talk, I've made numerous references to women. I've talked sometimes about birthing people and sometimes about birthing women. It's important to be able to talk about about women when we talk about what's happening in childbirth, because as many of these reports on obstetric violence have recognized, this is a form of gender-based violence that is imposed on women as women. And so we can't talk about that and its root causes unless we're able to talk about that. But that is not to ignore the fact that many of the people giving birth do not identify as women. They identify as transgender or third sex and third gender, but they might still have the anatomy that enables them to birth a child, even if they are, for example, a trans man. And they too can be subjected to gender-based violence. And in fact, in fact, to multiple layers of violence, because there's that first level of sex discrimination that can happen against anybody simply because you are perceived to be female, regardless of your identity and how you see yourself. And then basically these conferences that I was able to participate in over the years in these different nations and learning from people in different health systems, what I came to understand is that for every layer of otherness that is projected onto a birthing person's body by their providers, the likelihood that they will be exposed to disrespect and abuse goes up. The likelihood that they and their baby will not survive childbirth goes up. And that's measurable by mortality disparities for vulnerable communities all over the world. But it's also true for disrespect and abuse in ways that is only starting to be captured through research. Solutions. Respect informed consent in all circumstances. Trauma-informed care is the lever we can pull to transform maternal health care. And Joan, you pointed out some of the new challenges we're facing since COVID and the ways in which COVID has been allowed to backslide maternity care from some of the advancements around respecting the rights of patients that it has made in recent years. But at the same time, we also have a growing recognition of trauma and its impact on health, on public health, and community health. And if there is an increased understanding of that, then what everybody working in maternal health care can start talking about is that we know that at least 1 in 3 women have been exposed to sexual violence or childhood sexual abuse before they come into maternal health care. And once we are willing to recognize that, then it should not be so hard to understand that the number one place to start in preventing trauma in maternal health care is to make sure that consent happens. And to understand, again, why do women experience these violations as a rape? It's not that hard to understand if you know that traditionally, any medical touching without consent was recognized as an assault or a battery, right? And so when you recognize that, then it should not be a surprise that a non-consented medical touching of the genitals might be experienced as a sexual assault, especially by a person for whom non-consented touching of the genitals triggers past trauma. That this can be avoided simply not by saying, do you have past sexual trauma? Assume everybody does. But by looking them in the eyes and saying, is it okay? So this is what I'd like to do. This is why I'd like to do it. These are the other options. What do you think? Do I have your consent to touch you? I can't tell you how many women who have spent the months or year plus after their birth crying in the fetal position, unable to function for their families, have said, if they had taken 2 minutes to talk to me and get my permission, I would have given it to them and I wouldn't be in the fetal position now. Training and support, understanding where the provider responsibility ends, and the birth plan can actually be a trust building tool. When you start from that understanding that the birth plan, the number one thing people are saying with that birth plan is, I want to make the decisions about my care. Here's what I anticipate my decisions would be. But because often the pushback on the birth plan is, well, little lady, we love birth plans around here, but you need to understand birth doesn't really always work out as planned, with the implication that if something goes awry and an emergency arises, we will take back the decisions. And so what needs to be said by the patient and understood by the provider is, no, things might not go as planned, right? So here's my plan for what I assume my default decision would be. If things change, I will continue to make decisions on the basis of advice and information from you. So the birth plan can be actually a way in which we get clear at the beginning. Do we have agreement that the patient can make the decisions? And if we do, then we can move forward to actually explore, why does the patient say no cesarean section? Why did you write this down? You don't actually mean that, right? You actually mean that if you needed one, you wouldn't mind it, but you don't want an unnecessary one, because that's what they mean, 99% of the time if they write that down. And so then that can just be a way of exploring and building trust. But all of that comes back to training, support, and the institutional factors that allow for those kinds of discussions that are necessary to prevent trauma and improve outcomes in maternal health care. At the end of the day, our challenge for this century is going to be to recalibrate all our health systems to respect and uphold the individual needs and human rights of all the stakeholders, the patients and the providers. I believe it can be done once we start from the human rights and work outward from there. So that's my talk. I realize I've pushed the hour, and I wonder if there's any opportunity or time for a talk, Joan.
Yeah, absolutely. We've built in obviously just a sort of a 15 minutes. So I'm really hoping, I would imagine you're going to have lots of discussion. I know Twitter is on fire at the moment, and there are comments obviously in the chat. As usual, Hermine, I probably have about 20 questions, so I will let everybody else in first because they may wish to say something. So just lots of claps and lots of delight at what you're saying, Hermine. So what I might ask you to do is to stop sharing. That's great, so we can actually see your face. And just any questions, please either raise your hand or speak up, or otherwise I can start, whatever suits. One of the things that I was thinking about, Hermine, while other people are trying to get their heads together, and it's something that I haven't been able to find. And we've had a recent case here in Ireland. It hasn't gone legal yet. It's just been in the coroner's court because there was a stillborn infant as a consequence. But have you come across anything where women have tried to exercise their rights under Article 3, where they were refused a cesarean section on maternal request and ended up having an induction of labour, which they felt was degrading, inhumane, non-consensual treatment?
Oh, sure. I mean, situations where women are denied cesareans that they requested and then had vaginal births that they believe caused them harm.
Well, the particular thing I'm thinking of is that the woman was having an induction, but the labour hadn't actually started, but her baby was discovered to be stillborn. There was no fetal heart a number of hours later. but it's on the basis that if I'm entitled to, you know, skilled care, and I'm entitled to be part of shared decision making and so forth, and I requested this cesarean section and didn't get it.
Yeah, I mean,
Very tricky ground here. So I'm just wondering how it's worked out with Article 3, because we've had a number of cases from Ireland. ABC are probably the most famous, where they may have succeeded under Article 8, but they've all failed under Article 3. You know, the bar seems to be quite high.
I mean, the request for cesarean section is a little different for the request to not have one, because you're actively asking for resources and the use of those resources on you in a way that I mean, if you're in a really high resource system that loves to section everybody, then very often the denial of a C-section to somebody is arbitrary and just one more form of manipulation and coercion. But if you're in a, you know, a situation with limited resources, it's a different story. So just you always have a right to refuse treatment, right? But it gets more tricky when you're actively asking for some kind of support, you know, but then that gets really, that's where that complexity around vaginal birth comes in. Like, has vaginal birth now become something that is active support or resources that you don't have a right to ask for? And the sort of framing of it as that is what makes women end up giving birth alone. Because again, it's like they're like, sorry, that's a service we're not offering you. So they're like, therefore, in order for my baby to come out my vagina, I can't come here. I have to stay home by myself.
Yeah, I just wonder when there will be one about the request for cesarean being denied, as you say, in resource intense countries.
I'm bringing one here. Yeah, I'm bringing one right here in the United States, where my client was. They anticipated a large baby. You know, she was gestationally diabetic, and they did the C-section, and she had been asking for a C-section the whole pregnancy because of her personal past trauma. And they were like, well, no, and you know, again, it's like the irony, because lots of other women at that same hospital are pressured to have C-sections they don't need and don't want, right? But so it's like, it comes down to, what do we want to do? And so she, you know, she was asking for it the whole time. And then at the end of the pregnancy, they did an ultrasound, and they said, well, we think your baby's like 9.5 pounds. And she said, could I have a C-section? And they said, only if it's over 10 pounds. That's our policy, only if it's only 10 pounds. Baby came out 10.5 pounds, had a shoulder dystocia, face turned black, spent months in the NICU, you know, and like, so yeah, we're gonna pursue some accountability for that.
Yeah, and I guess the other thing, I mean, I love what you were saying about the Canadian obstetrician. I think it would be fantastic if that kind of support was available to obstetricians from their, you know, member groups, you know, internationally. I'm not so certain. And as you say, the failure of advocacy is so obvious in the defence side, in particular in many of the cases. But there are a number of issues with providers not being responsible for the outcome after informed consent. We certainly had an issue here where a woman was looking for a vaginal birth after cesarean as a home birth, not as a hospital birth. And essentially what happened was the state decided we could only provide support if you sign a waiver for any negative outcome to yourself or your baby. So not quite as let's just say a supportive position as the Canadians appear to be taking. So I'm just wondering, is anyone else any questions? I know, Michelle, we were talking earlier about some of the things that are happening where you are in South America. So I'm just wondering if you've any similar, you know, experiences or things that we can learn from in the way that Hermine is talking about.
Yes, it all makes so much sense. Thank you, Hermine. It's wonderful. Yeah, it happens such as she's describing, and but we have a lot of, I think, hierarchy, and patients' rights are much less developed in our countries. That medical hierarchy is very, very strong, and patients' rights are just beginning to be discussed in these terms. Like, so it makes a lot of sense. And especially, I love the part where Hermine said that the obstetric story is that cesareans are maybe performed for fear of liability, but economic incentives weigh so much. I think that's a super important topic that we should be looking at, because it's really, in systems where there's private and public health and mixed systems, it's really driving the cesarean section. We have many maternities with 100% of cesareans, and obstetricians are paid better salaries if they do more cesareans, because they make the machine work in a better way. So they have over incentives to do more cesareans. So that's a very huge topic in many countries, I think.
Yeah. Hermine, there's another question in the chat that asks, is it a mandatory requirement in the US for a practitioner to attend the birth?
Yeah, so I put a little bit of a response in the chat as well. There's no duty of non-abandonment, as you know, many nations have a duty of non-abandonment for the providers, like a midwife or individual providers. Hospitals have a duty of non-abandonment in the form of there's a law called EMTLA, Emergency Medical I'm forgetting the acronym, but it says that once a patient shows up having contractions, they must be cared for. And the hospital can't just kick them out and say we can't care for you unless the hospital actively transfers them to another facility. And yet this happens on a regular basis where people are, and in fact, yeah, it happens. And in fact, I've heard of nurses being told by their hospital, you know, when she said no to the whatever, you should have called security to have her thrown out. And the nurses will be like, what are you talking about? She would have had the baby on the way to the elevator. And they'll be like, not our problem. You know, it's like the obstetric violence laws. The laws are there, but the laws are not being enforced, right? And part of that is because we actually have to bring the actions to enforce the laws and keep bringing them until they start to be effective.
Yeah.
I see that Murto Kronaki has something to share.
Oh, yes, hello, yes, Kronaki.
Hi.
I want to complain, John, why this discrimination? I have many more cesareans in Greece and lots of obstetric violence. you know.
So you have both, Myrtle.
I want to claim my rights to obstetric violence. So Michelle has come to Greece as far as I know, so I can discuss these things. And Olga Gunin knows about this, I suppose. I have a 6% cesarean section, and you know, the notion of informed consent, I'm so happy Hermine spoke about that, because it's, you know, being ridiculized here. Anyway, thank you very much for the talk.
My pleasure. And the reason I pointed to Konovalova is you guys can all go print that out. And what's so great about it is that it cites all those different treaties. So bring it into your hospital and be like, look at this and this and this and this. And then tell me that we don't have to follow that law. Because our nation is a signatory to this treaty and this treaty and this treaty, this treaty. Yeah. Why aren't we doing it?
Yeah, very, very good question. Yeah, I've lots of thoughts on that. I might keep them to myself for now until we have something like a round table, which is very much focused on, you know, how we can, I suppose, exercise those rights in a more effective and efficient and pragmatic way, rather than always having to end up in a court, but how we might actually be able to change practice by exercising them in a more sensible way, I think, which would be great. So just to say, Hermine, thank you so much. The place is buzzing. Yes, you've got Cyprus and everywhere else saying we're in the same challenges. We've got huge variations in cesarean section rates, but we don't have an overall cesarean section rate as high as the US just yet, but I can see us getting there, and I can see it definitely happening post-pandemic, and then reversing is going to be a major problem. So I think we will be having these discussions over and over again and trying to work out how we can collaborate effectively together and, you know, become a strong voice. So
Joan, I think Julia had something to share. Do we have time to hear
yeah,
from one?
Yeah, we do. Yeah, sorry, Julia, I missed that.
Oh, thank you, Hermione. I was just wondering if you could say something about your impression of the outreach of the human rights in birth movement into the obstetric community too, because often, you know, like here it's kind of preaching to the converted, and there's lots of midwives here. There are a few obstetricians too with cost, but maybe I would just be interested, what is the reception, and if you see like a development or, you know, like a start of discourse in this professional group too.
So I have not experienced medical obstetrics embracing the understanding that it's doing it all wrong and it really needs to change. So, and I remember way back, you know, when I organized that first conference in The Hague on human rights in childbirth, getting in touch with the Dutch OB-GYN Society and VOG to ask if they would be involved. And I remember somebody from there saying that if we called it human rights in childbirth, it would be far more palatable to them than if it was called women's rights in childbirth. And it wasn't because they were being trans-sensitive. They weren't interested in women's rights, and they didn't want to be told that they were violating them. And in fact, the resistance that many obstetricians have to the idea that they're violating patients' rights and to the phrase obstetric violence, right? They get defensive and stuff like that. It's similar to the response that obstetricians made to Ignaz Semmelweis back in the day when he told them, wash your hands. And they said, how dare you, we're gentlemen, our hands aren't dirty. So that's something to keep in mind with all the hubris and pride that is brought by providers to this issue. So, I mean, in short, I can count the number of OBs who really understand informed consent on 1 to 2 hands. I'm happy that it might have grown past 1 hand. And I don't think that this is going to change without, rigorous advocacy and honestly without government assistance, because right now the government is allowing the industry to set the standard, and the standard violates the law. So until and unless the patients continue to insist that their rights be upheld, they're not going to be, because the way that rights generally work in all areas is that those who violate the rights don't say, you know what, we realize we've been violating your rights and we'd like to volunteer to stop. It's the rights holders who say, you know what, you've been violating our rights and you need to stop. That's how that changes. And that's what I perceive to be the only way in which this is going to change. But a lot has happened in the last decade. Since I've begun this work, Katerina can tell you, as a consumer advocate, these concepts weren't on the table the way that they are now. We wouldn't be having a conference talking about maternal trauma and trauma-informed care. And obstetric violence being recognized by the UN. That's all. So I feel hopeful that this is an area where we can make positive change.
And I suppose just to say that we do have obstetricians in the action who clearly are very concerned about improving things for women. I guess what we need to do as well, and I know we were talking about trauma-informed care earlier, is bridging that gap and kind of working together and trying to change as an interdisciplinary group, not just accepting that it's one group that are doing this, because certainly speaking as a midwife, it's absolutely for sure that midwives are doing this.
100%, and nurses too. And yet I want to speak to this idea that this is a blanket, that I'm bashing OBs. Of course, obstetrics is made up of individuals, right? And at the same time, obstetrics is also a profession that has trends. And that profession as a group and as within its standards of care is violating the rights of birthing people. And so we should be able to talk about that if we're willing to recognize those rights as mattering, without saying, how dare you say that, are you saying that all OBs are bad? In the same way that we can talk about the fact that racism exists and the fact that white people conduct racism on Black people in the United States, without saying, hey, you're insulting all white people and making it about that. Obstetrics has work to do, and any individual OB-GYN who recognizes that they are not violating patient rights should be excited to do the work to make the other OBs stop doing it, because they will be able to recognize that the other OBs are. And similarly, on Semmelweis, to some extent, medical students went from body to body, but 100%, it was the OB-GYN societies that responded to say, you are wrong. It was the lead OB-GYN from Germany who responded to Semmelweis in Hungary to say, you are wrong, I will go to battle with you, and made it his business to make a formal policy where his students and those doctors in training had to go directly from autopsies to the care of women. And it was his OB-GYN society that had him institutionalized in a mental institution and killed in the process. That's the story of Ignaz Semmelweis. It's true.
And if we take a final question from Sandra Morano.
Yes, I'd like to call the attention of all of you that the majority of obstetricians now are women. In Italy, this is the first choice after the medical degree. And in Europe, I think that the trend is similar. I think that it's time for us to take in consideration this important point, because women are attracted by this profession, and they go in the labor world. They leave their childbirth, for instance, and they live with midwives and women. I think that this interesting conference pointed some issues, such as the role of institutions, the standardized care, the insurance medicine that we learned by USA, unfortunately, because in Italy, in Europe, and some decades ago, we didn't use this kind of medicine. So it's very interesting highlighting this point, but this is an important struggle we in Europe and also in USA, of course, we did from some decades ago. We remember someone cited Marsden, Wagner, and others. So we are struggling just for not dividing women, because this is one of the first things I already pointed in all the courses I attended. I am an obstetrician, because otherwise we are destined to not to have any other progress in our work, daily work, because we have to, our commitment now is to change this kind of institution, the education institution, the attention to the women, the women perspective in education and in practice. Otherwise, we will be already divided. I struggled for all my professional life, talking against the ob-gene. Who was the ob-gene? Me was the ob-gene, and a lot of midwives against the ob-gene. Now the ob-gene is a woman. We have our first duty is to work for a progress, to work for putting the new words of feminism into our profession. It's a very difficult and long way, but we start to speak with, first of all, with institution, with academy. I think that also in USA and something is happening in Europe, but it's very important to change our way of learning, teaching as a woman. Do you understand? Do you imagine? Did you try? Perhaps you do that in your daily practice? Teaching as a woman, learning as a woman, practicing, looking in the eye as a woman when you are assisting a woman. So I think that this is our new and very difficult issue.
Thanks, Sandra, for that. And I'm kind of hoping that our cost action is at least trying and that we're working together with that vision, and that it's a great place to have multiple perspectives and to see things from so many different directions. I know every time we meet, I learn something new and see another perspective and feel that I've been handed another tool to try and do things better. So if I could just say once again, Hermine, thank you so much. I'm sorry for taking so much extra of your time, but clearly you can see the interest in your talk, and you can see it from the chat and from Twitter. And just to say thank you so much for sharing with us today. We really appreciate it. It's been incredibly stimulating and amazing. So virtual clap. I'm sorry you're not here to hear us all applauding in person.
Thank you all, and thank you for the discussion and the comments. I really appreciate it all. And
Thanks,
thank you for
and-
your work, your great work to make maternal health better.
Well, we're trying. We'll tell you if there's
Awesome.
any impact or not.
We'll tell each other. Let's all keep it
Exactly.
up.
Exactly.
It
Thanks.
needs all of us. Thanks, everyone.
Thanks so much. Thanks,
Enjoy
Hermine.
your day and the conference.
Will
Thank
do.
you again
Thanks
for
a
including
million.
me, Joan. Bye-bye.
Take care. Take care. Bye. Okay, everyone. Inga might just correct me. I thought that there was a lot of buzz in the chat and on Twitter, so apologies for going over time, but I thought it was probably the better thing to do.